Hello and a very warm welcome to a brand edition of In Depth with me, Frank Pereira. On Monday, Rajya Sabha Chairman Venkaiah Naidu rejected the notice given by opposition parties for the removal of Chief Justice of India Dipak Misra. In arriving at his decision, the chairman held detailed personal conversations on all aspects arising from the notice. He also considered each of the allegations made in it individually as well as collectively. The chairman said he had come to the conclusion that the motion did not deserve to be admitted, and on careful analysis and reflection by him, he had found there was virtually no concrete verifiable imputation. So what made the chairman come to the conclusion? What were the grounds on which he rejected the notice? Why didn't he find the notice worthy of being admitted? We consider all these questions in depth today, while also revisiting the process by judges. How can they be removed? Rajya Sabha Chairman Naidu's rejection of the opposition notice to remove Chief Justice Dipak Misra triggered a spate of reactions. The Congress said it will challenge the order in the Supreme Court. Let's take a look.
Rajya Sabha Chairman Venkaiah Naidu on Monday rejected the notice given by opposition parties led by the Congress for the removal of Chief Justice of India Dipak Misra. The decision was announced after the chairman held extensive consultations with top legal and constitutional experts on the matter. Rejecting the petition, the chairman said it lacked substantial merit and that the allegations were neither tenable nor admissible. The 10-page order of the chairman said, and I quote, "I have considered the material contained in the notice of motion and reflected upon the inputs received in my interaction with legal luminaries and constitutional experts. I am of the firm opinion that the notice of motion does not deserve to be admitted. Clearly, this is an internal matter to be resolved by the Supreme Court itself. Going through the 5 allegations mentioned in the notice, I am of the view that they are neither tenable nor admissible." Calling the chairman's order unprecedented and hasty, the Congress said it will challenge the chairman's decision in the Supreme Court.
We will certainly move a petition in the Supreme Court to challenge this order. And we are confident that when we move that petition, the Chief Justice has nothing to do with it. When we move it,
the ruling BJP, meanwhile, has welcomed the chairman's decision.
वो उच्चतम न्यायालय के मुख्य न्यायमूर्ति के बारे में उन्होंने आपत्ति जताई। बजट सेशन में पूरा बिना कोई कारण पार्लियामेंट चलने नहीं दिया। अभी होकर के भारत के महामहिम उपराष्ट्रपति के जो निर्णय है, जो संविधान के तहत निर्णय है और उनके अधिकार क्षेत्र में है, उस निर्णय के बारे में प्रश्न चिन्ह खड़ा कर रही है। इसलिए मैं इतना ही कहना चाहूँगा कांग्रेस को, यानी चुनाव हारने के और ये हार के मुकाबला करने के इस निराशा और हताशा में संविधान के सभी संस्थाओं के बारे में ऐसे बर्ताव ठीक नहीं है।
7 opposition parties led by Congress moved the notice on Friday, accusing him of 5 counts of misbehavior. The opposition leaders had met Rajya Sabha Chairman Venkaiah Naidu and handed over the notice with signatures of 64 MPs and 7 former Rajya Sabha members who recently retired. The Congress notice came a day after the Supreme Court rejected a petition seeking an independent probe into the death of Judge B.H. Loya. With Kriti Misra, Vishal Dahiya, Rajya Sabha TV.
The Rajya Sabha chairman cited 22 reasons for rejecting the Congress-led opposition parties' notice to remove the Chief Justice of India. The overriding message was that the notice lacked substantial merit.
Rajya Sabha Chairman Venkaiah Naidu reportedly held extensive consultations with top legal and constitutional experts before rejecting the notice given by the opposition parties. The chairman cited lack of substantial facts to hold the Chief Justice guilty of misbehavior. In his order, Naidu said in that he had detailed personal conversations on all aspects arising from the notice, adding that he considered each of the allegations made in it individually as well as collectively.
The most perfect decision has been taken by the Honorable Chairman of Rajya Sabha. There could not be any other decision on this issue. He applied his mind properly. He consulted the legal experts and other prudent people, and thereafter he took the decision not to admit this motion. And I think that the entire country, all the sensitive citizens of the country, they are happy with the decision.
Based on latest reports, here are the reasons why Naidu rejected the notice against CJI Misra. MPs who presented the motion are themselves unsure of the charges, as they use words like may have been, likely, appears to be, and it does not constitute proof against the CJI. He said, for example, the motion uses language like the facts and circumstances relating to the Prasad Education Trust case show prima facie evidence suggesting that the Chief Justice of India may have been involved in a conspiracy of paying illegal gratification. Such phrases, the dismissal letter states, indicate a mere suspicion, a conjecture or an assumption. Naidu's order further suggested that allocation of cases is an internal matter of the Supreme Court. Going through the 5 allegations mentioned in the notice, I am of the view that they are neither tenable nor admissible. The allegations emerging from the present case have a serious tendency of undermining the independence of judiciary, which is the basic tenet of the Constitution of India. The Rajya Sabha officials found that opposition parties violated the parliamentary rules by making public the contents of the motion before it was accepted by the Rajya Sabha. As per the provisions in the Handbook of Rajya Sabha members, no advance publicity should be given to any notice to be taken up in the House till it is admitted by the chairman. Naidu's order said that motion mentioned unverified charges which do not warrant further investigation. On a careful analysis and reflection, I find that there is virtually no concrete verifiable imputation. Either the allegations are within judicial domain and concern the internal judicial processes, or there are substantiated surmises and conjectures which hardly merit or necessitate further investigation, it said. He asserted that no credible or verifiable information giving indication of misbehavior or incapacity is made in the charges against the CJI. In his order, Naidu said that he found that there was no proof available to back the 5 allegations leveled against CJI Dipak Misra. Kriti Mishra's report for Rajya Sabha TV.
Well, it's time for a short break now, but our program will continue on the other side. Stay tuned. Welcome back. You're watching Rajya Sabha Television. Well, the chairman took the opinion of the top 20 law and constitutional experts before rejecting the notice related to the removal of Chief Justice Dipak Misra. Calling the removal notice a politically motivated decision, legal experts said such notices shouldn't be made a political weapon against the judiciary.
Chairman M. Venkaiah Naidu consulted famous law and constitutional experts of the country on the matter. Senior advocate Falin Nariman said, move by political parties will not only diminish the public's faith in judiciary, but will open the door for the ruling party to move against a judge if it does not like a particular judgment. It is imperative to have extraordinarily important grounds and cogent proof to remove the Chief Justice. Former Chief Justice of India T.S. Thakur described the removal of the Chief Justice as unfortunate. He said it is extremely unfortunate that the top judiciary is faced with such crisis. Justice Chellameshwar of the Supreme Court said that removal of judges was not an answer for every problem in the higher judiciary. There have to be other mechanisms in place to deal with such problems. Former Attorney General Soli Sorabji said that the notice to remove the Chief Justice is the most fatal step to harm the judiciary's independence. He also called it a politically motivated step.
But of course, there may be cases where there is judicial misbehavior or put misbehavior, but that must be in connection with the discharge of the duties in the High Court or Supreme Court, not some unrelated incident years back.
Former Secretary General of the Lok Sabha and Parliamentary Rules and Procedures expert Subhash Kashyap called it pure party politics. The purpose seems to be to embarrass the government and the ruling party. Former judge of Delhi High Court and a senior lawyer of the Supreme Court, R.S. Sodhi, described the notice as the most immature move the Congress had committed in its history.
आपका पॉलिटिकल एजेंडा जो होता है उसको पॉलिटिकली सॉल्व कीजिए किसी दूसरी इंस्टीट्यूशन को और वो भी जुडिशरी को जो आपका लास्ट सिटिडल है इसके अलावा आपके पास कुछ भी नहीं बचा आप खुद अंदाजा लगा लीजिए कितनी कदर करती है जनता पार्लियामेंटेरियंस की कितनी करती है एग्जीक्यूटिव की और कितनी करती है जुडिशरी की ये लास्ट था जुडिशरी जिसको आप गिरा रहे हो
Congress leader and former Union Law Minister Ashwani Kumar said that moving a removal motion against the Chief Justice was an extreme remedy and it could have been avoided.
Unprecedented situation है हमारे पास कोई प्रेसिडेंट नहीं है कोई पहले का कोई फैसला नहीं है जिसके मुताबिक हम ये आज कह सकें कि आगे क्या होगा जिन सदस्यों ने इस मोशन को प्रस्तावित किया था वो अपने विवेक के मुताबिक इस पर फैसला करेंगे.
According to retired Supreme Court Justice B. Sudarshan Reddy, the notice to remove the Chief Justice was a suicidal step. At first sight, there is no material to establish the charge. Irregularity does not amount to misbehavior. Bureau Report, Rajya Sabha TV.
Well, removal of judges is a process laid down in the Constitution. Let us take a look at what are these provisions and how does the process occur.
Removal of high officials of government for violating the Constitution is a judicial process. It involves a legislative body formally levelling charges against the functionary concerned, and it is done by Parliament. The process involves high official, the President, Chief Justice of High Court and Supreme Court, and the Election Commissioner of India. Article 56 of the Indian Constitution says the President may, for violation of the Constitution, be removed from office before the expiry of the term. Article 61 explains the procedure for removal of the President. Under this, when a President is to be removed, the charge shall be preferred by either House of Parliament. However, Article 124(4) of Constitution of India lays down the procedure for removal of a judge of Supreme Court and High Court that is applicable to the Chief Justice as well. A judge can be removed only through a process of impeachment on the grounds of misconduct and inability.
Impeachment motion can be moved against a judge of the High Court or the Supreme Court, all Chief Justice of the High Court and Chief Justice of the Supreme Court, on two grounds: proved misbehavior and incompetence, incapacity. Proved misbehavior and incapacity. Incapacity can be physical incapacity or mental incapacity.
The Constitution provides that a judge can be removed only by a presidential order based on a motion passed by both Houses of Parliament. The procedure to remove judges is elaborated in the Judges Inquiry Act 1968. The Act sets out the following steps. It says the removal motion may originate in either House of Parliament. At least 100 members of Lok Sabha or at least 50 members of Rajya Sabha may give a notice of the motion to Speaker or Chairman. The Speaker or Chairman may then consult individuals and examine relevant material. Based on this, they may refuse or accept the motion. If the motion is admitted, a 3-member committee has to be constituted to investigate the complaint. The committee will have a Supreme Court judge and a distinguished jurist. The committee will frame charges on what the investigation will be conducted. A copy of the charges will be forwarded to the judge, who can present a written defense. After investigation, the committee's report is to be put forth before the relevant house by Speaker or Chairman. If the committee finds the judge guilty, the motion for removal will be taken up for consideration and debated. The motion for removal is required to be adopted by each House of Parliament by a majority of the total membership of that House, or a majority of at least 2/3 of the members of that House present and voting. If the motion is adopted by this majority, the motion will be sent to the other House for adoption. Once the motion is adopted in both Houses, it is sent to the President, who will then issue an order for the removal of the judge.
The impeachment will be preceded by an inquiry under the Judges Inquiry Act. So when the motion is moved before the Rajya Sabha, it can be by 50 MPs. If it is in the Lok Sabha, it has to be by 100 MPs. And after the 50 MPs move the chairman of the Rajya Sabha, then the chairman can consult anybody he feels appropriate. So he could be a legal luminary, he could be an eminent legal person, he could be the Attorney General, anybody he feels he wants to consult. And after that consultation, he can reject the motion at that stage. If he were to, supposing, accept the motion, then a 3 judges inquiry will be constituted consisting of a Supreme Court judge, a High Court judge and an eminent jurist, and they will then inquire the matter.
Majority of the members present and voting, a majority of the total membership of the House, and 2/3 of the members present and voting. That is the condition. That is a special majority which is normally required for an amendment of the Constitution and all that. So that special majority is required for impeachment. So if the motion secures this majority, special majority, then the House, this will go to the other House. Suppose it takes place in the Rajya Sabha, it will go to the Lok Sabha. There also the special majority is required for passing this motion. After it is passed, then each House will send an address to the President.
But before the process of removal starts, the person against whom the motion has been taken up can present his side of version before the House. Bureau Report, Rajya Sabha Television.
Well, let's look into how many judges have had to face motions for their removal in the country. And I'm going to leave you with this report.
The process to remove important persons from constitutional post is a long drawn-out one. It's deliberately complex so as to allow these important people to do their job without fear. However, if any of them is found involved in a misconduct or violation of the Constitution, they can be removed. Current Chief Justice Dipak Misra was the first CJI against whom such a notice for removal was brought. The process to remove the Chief Justice of the High Court is similar.
Inquiry will be constituted consisting of a Supreme Court judge, a High Court judge and an eminent jurist, and they will then inquire the matter. And after that inquiry, again, if he is found not guilty, then the matter can close at that stage also. If he is found guilty in that inquiry, then the matter goes to the Houses, and both the Houses have to vote by a majority of the total House and 2/3 of the members present and voting.
Justice V. Ramaswamy was the first judge against whom the removal proceedings were initiated. This was when he was sitting judge of the Supreme Court. Before this, Justice V. Ramaswamy was the Chief Justice of Punjab and Haryana High Court. In 1991, serious charges of corruption were levelled against him. Apart from this, there was also an issue of discrepancy in his appointment. In 1993, a removal motion was brought in the Lok Sabha, but due to absence of 2/3 majority, it could not be passed. However, Justice V. Ramaswamy later resigned from his post.
The case of Mr. Ramaswamy, Justice Ramaswamy himself did not appear. And of course, he protested against the whole proceedings, right from the formation of the committee and so on. But in that case, the committee found him guilty of corruption. That is why it came to Parliament. That was the final stage. And then the lawyer appeared on his behalf. So the proceedings went on for three or 4 hours. After that, when it was put to vote, it did not secure the majority.
V. Ramaswamy going up to the voting in the House, which failed. I don't remember any other judge's impeachment going up to the House, but there are instances where judges have faced the inquiry, like there is a judge, Madhya Pradesh judge, whose inquiry is pending. And there are some cases where when the impeachment motion was moved at that stage, only people resigned. So,
Justice P.D. Dinakaran was the Chief Justice of Sikkim High Court. In 2009, Rajya Sabha MPs wrote a letter to then Vice President Mohammad Hamid Ansari and levelled 16 charges against him, after which the process to remove him from the post was initiated. The Rajya Sabha Chairman Ansari set up a 3-member committee to look into the allegations. But a few days before the hearing, Justice Dinakaran resigned from his post. Justice Soumitra Sen of Calcutta High Court was the second judge to face a similar motion for removal. In 2011, he faced a charge of misconduct, after which a motion was brought in the Rajya Sabha. The upper house passed the motion, which was then sent to Lok Sabha, and just before the voting, Justice Sen resigned. In 2015, 58 Rajya Sabha MPs moved a notice of removal against Justice J.B. Pardiwala of Gujarat High Court for his objectionable remarks on the issue of reservation. Just before then Chairman Mohammad Hamid Ansari was about to take decision on this, Justice Pardiwala resigned, after which the motion against him was also taken back. In 2015, Rajya Sabha MPs were about to bring a motion against Madhya Pradesh High Court Judge Justice S.K. Gengale, but allegations of sexual harassment against him were not proved during the investigation. Apart from this, efforts were also made to bring in removal motion twice in 2016 and 17 against Justice C.V. Nagarjuna Reddy of Andhra and Telangana High Court, but these proposals never received concrete support. Bureau Report, Rajya Sabha TV.